Hi everybody, welcome back to weekend number 3 rather of the Sahamati account aggregator hackathon. There's only 1 week to go now until the final projects are submitted, so we're super excited, and we hope you are as well. This weekend we have a number of interesting masterclasses for you, and before introducing our speakers for this session, I'd like to just do some housekeeping as usual. If you have any questions around the presentation, how it needs to be done, who to reach out to get some feedback or to speak to mentors, please reach out to me. We're active on the Slack as well as in Airmeet on the chat. So please do that. If you haven't RSVP'd on DevFolio and checked in on the Slack, then we won't be able to accept your presentation. So make sure that you do that. And yeah, that's all the housekeeping for now. So for this session, it's actually our third legal session because it's a very interesting and complex topic, and we're really lucky that we've had fantastic speakers for all three of our sessions. Actually, last week we were supposed to have Vinay Kesari as a speaker in the session about how to apply for an account aggregator license and to become an FRU. But unfortunately, he's unwell. Thankfully, he's with us today, or he was until 1 second ago, but I'm sure he'll rejoin soon. But we have Vinay Kesari, who's the general counsel of Setu, and prior to that, he was a policy researcher and lawyer in Delhi. We also have Matthew, Ankita, and Adya from Spice Route Legal. You guys have met Matthew and Ankita before. Adya joins us today. And we'll do an interactive session about privacy, data security, and the account aggregator regulation. So we wanted to be very interactive, lots of questions from you guys. So please raise your hands if you'd like to come on stage, ask a question. Alternatively, you can put a question in the questions tab on the right side. So without any further ado, I'd like to introduce Adya. Adya, over to you. Thank you for being with us. Oh, sorry, and one last thing. Can we have a very warm virtual welcome for our speakers, please? Thank you, everyone. Over to you, Adya.
Wow,
I love those hands.
Thank you for that, Ariman. Hi, everybody. So we hope this is going to be an informative and exciting session. What we've tried to do, at least for the first couple of minutes, is to kind of set the context of what the existing data protection legal framework is in the country today. There's been a lot of hue and cry and excitement about an upcoming data protection law. So what I'm going to try and do is set the context on how it's going to interact with the AA ecosystem. The problem with doing a deep dive into the new law is that we're going to be sitting here for probably weeks and weeks just to discuss, every nitty-gritty that arises out of it. So in the interest of time and to make sure that, we have a fruitful discussion, I'm going to limit it to how the new data protection regime is going to interact with the AA ecosystem. So to begin with, I think it's always helpful to have a look at what the existing data protection regulations are in the country today. There's a common misconception that data protection and the privacy framework now is either non-existent or is extremely light touch. While these are in their own respects, accurate, it's helpful to know what the laws are. And, it surprises people, but it's not as light touch as you think they are. So just to kind of set the framework, you've got this law called the Information Technology Act. And you have a set of rules that were issued by the government under the Information Technology Act in 2011. They were called the Reasonable Security Practices and Procedures Rules. The idea is that any company that kind of handles or processes sensitive personal data or information in India will be required to comply with the data protection rules. Now, very simply, there are about 8 or 9 things you need to do under these rules. You've got to make sure that you've got users' consent before you process their data, before you handle their data in any manner. You've got to make sure you've got a privacy policy in place that tells users what they're supposed to do, what their rights are and how you handle their data and who you are and your processes that you've implemented. You've got to make sure you don't use data for purposes beyond which you were collected them for. So, for example, if you've collected data for, say, loan disbursement, under the SPDI rules, that's what I'm going to refer to them as. These are the data protection rules. You're not supposed to use the data for purposes beyond the loan disbursement. You've also got to give users the ability to review their data. You've got to give users the ability to access the data. You've got to give users the ability to opt out of the consent that they provided you to handle their data. You've got to make sure that your security safeguards are in place. You've got to make sure you've got a grievance officer. So in the last minute, I've pretty much summed up everything you need to do under the SPDI rules. And it's likely that almost all organizations, if not following all of them, have about 5 or 6 of these requirements in place. So within the account aggregator ecosystem, and if you look at FIUs, and if you look at FIPs, if you look at account aggregators by themselves, it's likely that all 3 of these organizations have the requirements in place under the existing SPDI rules. It's not too hard, even if you don't, it's not too hard to get these in place. The problem, of course, arises when you talk about the new data protection bill. So just to set some context, there is a draft of the new data protection law that is modeled somewhat on, okay, not somewhat, quite significantly on Europe's GDPR. It is currently under scrutiny by a parliamentary commission. As of now, it's unclear when this law is going to be passed, but a lot of people think it will be towards the end of the year or maybe the first half of next year. What's significant about this law, at least, is that it completely changes the way you think about privacy right now. I mentioned 7 or 8 things you need to do under India's existing regime. The PDPB kind of amplifies this and makes your obligations 50-fold, right? Again, like I mentioned earlier, it's easy, to think about exploring what the PDPB is. That's what it's called, the Personal Data Protection Bill. If you want to kind of think about what the PDPB is, you want to talk about obligations, you want to talk about data subject rights, you want to talk about penalties, you want to talk about the data protection authority that is going to be constituted under the law, we're going to be sitting here for a very, very long time. So what I think might be helpful, and Vinay, Matthew, Ankita, please, feel free to let me know if you disagree, is that I think it might be useful to look at the PDPB in the context of the actors. So you've got the data fiduciaries, who are entities that decide how data is going to be processed, and kind of focus on their obligations under the law. And also, it might be useful to kind of touch upon what rights users have under the law. Maybe look at that and do a comparison with how the system is, how the account aggregator ecosystem kind of overlaps with, and in certain places maybe even conflicts with the kind of framework that the PDPB intends to put in place. Okay, I saw a couple of thumbs up, so I'm going to assume that it's okay with the other speakers. I think, so when we start talking about the PDPB, there are 4 actors, right? You've got, of course, the users or the data subjects, and the law is modeled to kind of put their interests at the forefront. And then you've got 3 types of organizations who get affected by the law. You've got something called a data fiduciary, you've got something called a data processor, and then you have something called a significant data fiduciary. A data fiduciary, very simply, is the organization that collects the data and decides what you're supposed to do with the data. You've got data processors, and the easiest way to think about data processors is a form of service provider to the data fiduciary. They work on behalf of the data fiduciary, and while they have certain obligations under the law, the assumption is that they're working for the data fiduciary, and it's the data fiduciary that undertakes those obligations of compliance. Then you've got something called a significant data fiduciary, which is a regular data fiduciary, but because of the kind of data they process, their compliance obligations increase exponentially under the law. If you look at the account aggregator ecosystem, FIUs and FIPs, and this is just a guess because we're still waiting for more guidance, but just with regard to the amount of financial information that both FIUs and FIPs are going to be processing, it's likely that they're going to be considered significant data fiduciaries under the new law, which means that they're going to have obligations that include things like you're going to need to appoint a data protection officer. You're going to need to undertake data protection impact assessments. You need to undertake audits once a year. You need to make sure you've got written records of everything you do. You've got to have systems in place that enable you to kind of give effect to users who come to you and say, hey, my right is being affected. I want you to fix it. So just from a compliance perspective, significant data fiduciaries, and this is just a guess, of course, almost all banks, any RBI regulated entity that deals a lot with sensitive information or financial information is likely to be considered a significant data fiduciary. Now, we've talked about, and it's also likely just because of the kind of access that FIPs are going to have under the law, that they're going to be considered significant data fiduciaries as well. Then you get to account aggregators as an entity, right? Because, just going through the guidelines and seeing how it practically works, you notice that account aggregators, all they do is kind of act as a pipe to kind of pass on data from FIUs to FIPs. So just thinking out loud, the fact that they don't actually store data, it seems unfair to categorize them as data fiduciaries. But I just think that while I'm going through the text of the new law also creates a concept called consent managers. And consent managers are data fiduciaries that enable users to give consent and withdraw consent and allow users to exercise their rights. Just going by that definition alone, I'm inclined to think that account aggregators are going to be considered consent managers under the new law. And because of that, they're going to have to comply with obligations that they needn't have ordinarily complied with, simply because of the fact that they don't actually store the kind of sensitive personal information that FIUs and FIPs do. So that's just something to consider. I'm going to keep throwing the term data fiduciary around, but these are, just to sum up, entities that have the highest degree of compliance under the PDPB. Now, that's just one important aspect to remember about the PDPB. I think there are two other things that it's important to set context, and then maybe we can move on to a certain number of questions. Is that any entity that wants to process personal data needs to justify the ground on which they are processing the personal data. That is, if I'm collecting data for you, I either need to have your consent to do so, or I need to, if I don't have your consent, have a way of justifying why I'm collecting your data. Now, there are other grounds on which you can process data under the Personal Data Protection Bill, but just for the purposes of this talk, I'm limiting it to consent, where you make sure that you only process data, collect data, store data, or analyze data based on your user's consent. And in the absence of consent, there is a reasonable justification for why you're doing so. Now, for example, if you are undertaking a kind of credit scoring exercise on your user, and the user doesn't give you consent to store or process their data, there are reasonable ways you can justify that collection, right? You can say that I need this for a credit scoring activity that is mandated under law. Hence, I can proceed, without your consent. But when you look at the account aggregator ecosystem, you realize that consent is the absolute foundation for how the system is going to work. There doesn't arise any question about relying on other forms of, trying to justify collection or processing or storing your data outside of consent. Consent's a very interesting concept, I think, under the Personal Data Protection Bill, because the law kind of sets down certain criteria you need to fulfill for consent to be considered adequate. You need to make sure that your users are informed of what they're consenting to. that they're well aware of the categories of data that they're parting with and the purposes for which they're going to be used. They're aware of how you're going to use the data and the third parties with whom you're going to share your data with. I think when you compare it to the existing law, which is kind of, for the lack of a better term, a kind of a wild west with how how we rely on data and how we use it, I think things are going to get much stricter under the new law, which also means that how you think about consent has to change very drastically. And I think this is where the account aggregator ecosystem provides a very useful practical example of how consent can work. Just by the use of consent artifacts and consent requests, just the amount of information you are providing to users to enable them to understand what consent is and how consent is going to work, who the party is with whom you're sharing data, for how long they can store the data, is an example of the information that users need to act for that consent to be valid. Right now, I click on a 20-page terms and conditions, and right at the bottom, I say I accept, and that is considered valid consent. Under the new law, that entire regime changes, right? And the account aggregator ecosystem becomes, I think, a great example of a practical implication of consent. Apart from consent, another useful thing to think about is data subject rights or your users' rights under the new law. Under existing law, I would think that rights are somewhat limited. You've got the right to access your data. I have the right to go to an organization that has my data and seek its correction. But the new law goes and kind of amplifies these rights a little bit. I have the ability under the new law to access my data, to correct my data, to withdraw my consent, to even ask organizations to erase my data. In a limited form, I have a right to be forgotten. I can go to an organization and prevent its disclosure as well. Now, what's going to be interesting to see, at least with the account aggregator ecosystem, is how FIUs, FIPs are going to implement processes to give effect to this right. Right? How are you going to build in processes to enable erasure of information if a user comes and asks you to erase their data? Do you have a process ready? And secondly, how are account aggregators going to feature in all this? Because while it's not a practical exercise right now, as I understand, under the new law, account aggregators could well have a more advanced function where they enable users to exercise these rights as well. So apart from just giving consent and withdrawing consent, they also have the ability to kind of on behalf of data users, seek things like erasure of data, or seek the correction of data, or seek updating of information. So it's going to be interesting to see how account aggregators also step up with the new law, and perhaps with the business of account aggregation as it stands today, maybe build upon that as well. So I thought, at least for now, it makes sense. We've spoken about the actors within the ecosystem, which are data fiduciaries. We've talked about consent. We've talked about things like data subject rights, and we've also touched upon present law. Matthew, Ankita, Vinay, any thoughts on this? Is there any other consent needed? Vinay, I think your mic's on mute.
Yeah, so I think if I had to focus on one thing that is most important to people, building products here, it is this question of consent.
Yeah.
And what it means. Of course, there are a lot of other things. You need to have a privacy policy in place. There's all of that other compliance, but that doesn't directly affect your, the product or the experience that you provide your end users. Where that UX really interacts with the law is this question of consent, right? And as Adya has been saying, under the PDP bill, which will probably become law sometime soon. Before AA becomes very big. I'm
Vinay, I've been saying that
confident.
When I have been saying that for 2 years now, I think. But anyway, go ahead.
I know. I know. I know. And now with COVID and all of that, I know there are a lot of other priorities. But I think it's fair to assume that it will, at some point, as A is matured, that will become law. And it probably the final law will probably look very similar to the current bill, at least in these respects, in the context of issues like consent and so on. So I think it's important to kind of break that down and understand what it means. So as you know, the primary purpose of an AA is, in my view, actually the term AA is a bit of a misnomer. I actually think that they're more of consent aggregators rather than account aggregators, because the true job of an AA is to make sure that consent is correctly obtained, and you as an AA are expected to be, the loyal sort of servant of the user, the end user, in respect of obtaining consent. So this is key to everything that you're doing. So there are two things to keep in mind here. One is, of course, the definition of consent, or rather the ingredients of consent. And, as Adya was saying, there are basically 5 elements to it under the PDP bill. It basically needs to be free, informed, specific, clear, and capable of being withdrawn. So to begin with, what does this mean? This means that when you are designing your screens, right, and the flows that you present to users, when you are asking for their consent with respect to, say, sharing a specific piece of data, right, that entire UX needs to kind of conform to these 5 elements. It needs to make sure that, so when you're designing that screen, you're designing the buttons, you're thinking about what language to use when you're asking for their consent, when you are deciding which information to display to them about, why this specific piece of information is being requested and what it is being used for. You need to make sure that all of this conforms to these. These 5 ingredients need to be there when you're designing all of this.
Can I have the freedom to interrupt you?
Yeah, absolutely.
Perfect. So as someone who's working internally within a company that is looking at this ecosystem, right, that is building infrastructure products for the fintech economy, just one question. So under the AA system, consent is tied into what is called a consent artifact, right, which is a prescribed set of consent fields that you need to get consent on, right? So it's not freewheeling privacy policy type consent or explicit consent in the context of the PDPB, but it's a very specific subgenre of that, right? Now, my take on this is, and I think a lot of industry disagrees, but my take on this is that just getting user approval for the consent artifact will not satisfy the legal requirement of taking explicit consent, because the artifact is neither layered, the artifact is not diagrammatic, there is no language requirements in the artifact yet. And so I was wondering, as someone who's also building products around this ecosystem, what would you think about the interaction between the consent artifact, which is a RBI-led account aggregator, Sahamati generated consent, mandatory floor for consent, and the slightly higher threshold of explicit consent under the RBI guidelines again and under the PDPP?
Right. So absolutely. So as you were saying, I think the important thing to keep in mind here is the RBI master directions, even though they came out in 2016 when the PDP bill did not even exist, uses the phrase explicit consent. Now, at that point in time, the phrase explicit consent didn't actually have any meaning, any specific meaning beyond the plain English meaning, right? Because the current law as it exists does not make a distinction between consent and explicit consent, as far as I'm aware. The PDP bill, on the other hand, does recognize this kind of new category of explicit consent, and it tries to flesh out what explicit consent is. It actually says that in addition to those 5 elements of consent, regular consent, if you are required to take explicit consent in certain situations, you need to do basically 3 additional things. You need to tell the data principal about any significant harms that may accrue to them because of the data that's being processed. The consent needs to be obtained. I have the exact phrase here, in clear terms, without recourse to inference from conduct in a context. I'm not entirely certain exactly what that means. I think we'll all have to figure out as a community exactly what that means. But it is very interesting because what it basically means is that you can't, again, you can't just infer from a person's actions that they have consented. So simply forms of taking consent, ways of taking consent that say, hey, by just using this product, you automatically are assumed to have given consent for A, B, and C. That may not satisfy the requirement of explicit consent. It would likely mean that you would need to still explicitly lay before this person what you're doing, what data you're collecting, what you're collecting it for, and so on. So that's the second. And the third is you are supposed to allow the data principal to give separate consent for, I don't want to misspeak here and paraphrase, but it says you must give them the option separately consenting to the purposes of operations in and the use of different categories of sensitive personal data relevant to processing. And I read this to mean that you need to give people more granular control over which pieces of data they want to share and for what purposes. If you are required to take explicit consent, that means you cannot make it a blanket yes or no. If you've looked at the way cookie consents work, in the GDPR, for example, when it's implemented in the best possible way, websites actually give you the ability to not just hit accept, but actually go in and make some modifications to exactly what that consent means, what it extends to, which pieces of data you're okay with being collected, and so on. So I would read it as something akin to that.
So very specifically, Vinay, just for the audience.
So I just want to come to your point.
Yeah.
Sorry. Okay. Sorry. Actually, if it's about this, please go ahead.
Yeah, it's the same point. So very specifically, are you saying that you agree with my position, which is that to satisfy the new legal requirements and even to satisfy implied legal requirements in the master directives, the FIUs and any consumer-facing business relying on AA data that's going to be piped down will have to take consent, will have to go beyond the consent artifact to get explicit consent.
Absolutely. So I don't think that the consent, I agree with you completely. I don't think that the consent artifact in any way, solves the legal, puzzle of what constitutes consent. The consent artifact is a technical tool which is used to record consent. It can't be tampered with. It has very specific fields. It standardizes the way in which you take consent. It makes it auditable in the future, and all of that, which is great. But it does not, as Matthew, as you said, it does not prescribe how you are actually going to take that consent from the user. Some of the content is contained there, but the actual wrapper around it, right? The language that you will use to communicate these issues to the user, the design of the screens and the kind of UX elements that are there, which you use to take this consent, ultimately to record this consent, none of that is prescribed in the consent artifact. So simply using the consent artifact does not mean that you would have satisfied your the legal requirement of taking consent and taking consent in a specific way. That is over and above the use of the consent artifact itself. The consent artifact is table stakes. I mean, it just has to be used. And thankfully, at least the consent artifact in this case is very clearly laid out. It's XML code. There's very little ambiguity about how to use it. But unfortunately, the law can't always be that explicit, and it's not really a failing of the law, because the problem is that the law you cannot prescribe everything. You cannot be overly prescriptive when you're writing a law because contexts change and products change. So some of these concepts like consent and the ingredients of consent and the ingredients of explicit consent, they may sound like confusing and like a little woolly, but there will be I think there will be more certainty that will come over time, which will be evolved through industry practice, which will hopefully come in because we will have a good data protection authority with knowledgeable people on it who will help guide the direction in which these standards evolve and so on. But the key thing to keep in mind while you're building is that just using the consent artifact does not mean that you have satisfied the law. You need to make sure that these definitions are satisfied.
Right. So to paraphrase one of my favorite professors, Professor Timothy Endicott, he says that vagueness is the biggest contribution of the common law legal system. But anyway, moving on. Okay, when I have one more question on this, right? And this is again, I'm kind of representing questions that I expect from the audience because we've had the benefit of interaction in the last week. So trying to bring it down to more practical chords. When either an FIU or an AM, and there's a little bit of a debate internally on whether both will, but let's assume when both of them interact with technical service providers, right, who are going to provide certain processing software analysis on the data. And again, as someone who's involved in the system, what are the practical considerations, and forget the law, like Adi, I'll come to you on the legal considerations, but what are the practical legal considerations, Vinay, that you would have when transferring data as an FIU to a TSP and getting it processed at that end?
Okay. So, to begin with, if you are an FIU right now, you are going to be, by definition right now, you are going to, in any case, be a regulated entity holding a license or a registration from one of the financial sector regulators. In the future, it's possible that FIUs can also be non-registered or licensed entities. In fact, that is what the master directions envisage, that basically more or less anyone can be an FIU. But right now, for good reason, it's been limited, and to be an FIU, you have to be a licensed entity. Now, if you are a licensed or regulated entity, in any case, your sectoral regulator, if that's the RBI or SEBI or whoever else, would have laid down like a whole bunch of guidelines about how you can deal with TSPs. So if you're RBI regulated, you have like the outsourcing guidelines, which are like pretty extensive, which talk about which are not specific to sharing of data, but they also apply to sharing of data. Essentially, if you outsource any part of your function to someone, you need to make sure that that entity conforms to these outsourcing guidelines. Beyond that, I think the key thing to keep in mind is that one, the TSP has to be subject to all of the restrictions to which you are subject. So you have to contractually pass on all of the restrictions which apply to you as an FIU, either by way of the law or by way of your contracts with the other entities in that ecosystem who you're dependent on or who you source data from. You need to make sure that you contractually pass on all of those restrictions to any TSPs that you work with as well. And the key thing here from a practical perspective is to make sure that the consent artifact. Now, the good thing is there's some certainty, that's there here. So you have the consent artifact, right, which lays down a whole bunch of things about your data retention, purpose limitation, all of that stuff. You need to make sure that all of that is completely observed by your TSP as well. So you cannot allow them to do anything that was not permitted at the time that the consent artifact was electronically signed, because you would effectively be, in my view, you would be violating the law if you did that. So you would need to make sure that you have very robust systems in place, both in terms of contract and ideally perhaps in terms of like technical systems and perhaps periodic audits and things of that sort as well, to make sure that they are not doing anything that you are not allowed to do.
Okay, perfect. And I'm going to ask, and I'm going to be the bully as the oldest one in the room. But I'm going to ask both Adya and so Adya is a certified information privacy professional, whatever that means. But I'm going to ask Adya a question on characterization. And Vinay, I'm going to ask you the same question, and I'll try and see if the two of you disagree on any points. Right? The first is on characterization of the account aggregator itself under the PDPB. Do you think that the account aggregator is, and Vinay, this is for you, do you think that the account aggregator is the consent manager that the PDPB talks about?
Yes, I believe that that concept was explicitly inserted into the new draft of the PDP bill. It was not there in the 2018 draft of the PDP bill. It came in the 2019 draft. And I think it is absolutely tailored to apply to AAs. And perhaps future entities like AAs that may be introduced in other sectors, like maybe health and like telecom or whatever else, right? But definitely it's tailored specifically to apply only to this. I don't think this concept exists in any other country, in any other law. It's very clear.
Let me put this to Adya, who's the regional privacy person. Are there other laws you've come
What this
across
is. I think it's also
which talks about consent?
Sorry, Vinay.
Vinay, your voice is breaking.
Sorry, Matthew. What were you saying?
Have you come across consent managers in any other laws?
Yes, because let's look at the GDPR, for example. There's no express carve out for something called a consent manager, at least to the best of my knowledge, within the GDPR. But you see a lot of entities functioning as consent managers and working in a manner to give effect to data subject rights. And Ankita, please step in here because this is definitely a fintech focused I mean, when you look at it from the sector itself, you do have open banking systems across the world, right? Yeah. And I think across the UK and I think in some capacity in the US as well, you have entities who function roles very similar to account aggregators and consent managers, where it's the collection of information, presentation of information, and giving effect to consent. So I would say that you do have, I mean, yeah, I think we do have entities that are
The
very
idea is there. Okay.
definitely
Now,
in some capacity.
we've been talking to account aggregators for a while, and we'll move from there. But just one last question, which is a debate we had internally as well yesterday. Do you think that account aggregators do under the present law, under the new law, or ought to do under the present law, under the new law, any guardianship function? Like, are they supposed to be people who promote more than their private interests? Are they supposed to make sure that even this is one for you as well?
Sorry, I was having an.
No worries. Yeah. We'll all pop out very soon. But the question is, do you think that account aggregators, as significant data fiduciaries, should perform a data guardianship function, which is basically actually act not just in their private interest, but also to some extent to the interest of the person providing data to the ecosystem? Let's go with Vinay first, because obviously, again, as someone who's working in an infrastructure builder, you're in the spotlight, right? We're all theoretical.
No, not really. But honest, even we are at this operating in a fairly all of this hasn't actually been. But so I think I was actually making another point when I got cut off, which is related to this, which is I think, as Adya was saying in the beginning, it's actually an interesting question about what an AA is. Is it a data fiduciary? Because it's not really processing data if you think about it. I mean, maybe in a very technical sense it is, because it's helping transmit it, but in a classical sense it is not. Right? And also it's important to keep in mind that legally speaking, the AA is Meaning
I
that,
think Vinay,
hi, sorry, did you lose me?
yeah, for the minute.
Oh, okay, sorry. I was saying that I'm just gonna
Yeah,
leave my
but
video
Ajay, what
off. I
about you?
think that might.
Is the day is an a data fiduciary? Is it a significant data fiduciary? Does the law say anything, or are you just guessing?
Right now, you'd have to guess because you don't really know the scope of what a significant data fiduciary is. My thought process is that, as Vinay mentioned, because a data fiduciary, because an account aggregator is actually not storing the data or doesn't really have access to the financial data in question, I think it would almost be an unfair categorization to classify them as significant data fiduciary simply because of the limited amount of data they're actually going to hold with them. But I think you raise an interesting question about guardianship because it almost seems like, and I'm just looking at a market like India, where it becomes, and we don't know how consent is actually going to work. I think the ability of account aggregators to go a step beyond what we do right now. And I think we've heard a lot of clinical arguments about, no, we just pass on the consent. I think there's a lot more that can happen, in terms of giving users the ability to exercise their rights, educating them about the rights. And obviously, I know the definition of account aggregation right now is limited, but I think when you look at the scope of what a consent manager can do under the PDPD, I think it opens up very, very interesting avenues for the kind of guardianship role that an account aggregator can play. And I think that's an important thing for account aggregators to consider in a market like India, where you perhaps don't have the kind of information and education and access and awareness that perhaps some countries like in Europe and the US do.
Okay, let's switch modes. Ankita, as someone who works primarily with fintechs, what do you think will be the role of the banking ombudsman in all of this? Is there a role? Do we need a data ombudsman? What's the plan?
So we definitely need a banking ombudsman from an AA perspective, but the ability for an ombudsman to step in case of any data breaches at the FIP or an FIU end would be very limited, right? A customer's interaction with an AA is limited to the client-facing customer app that the AA has, which is essentially with respect to the consent that was given and probably where the consent was revoked. So their rights and obligations and any complaints would be with respect to that small aspect with respect to their interaction with an AA, right? Any data used in excess of the purpose at an FIU's end will have to be dealt with the FIU separately through their ombudsman. Similarly, any right of revocation with respect to the original source of data, which probably lies with the FIPs or the depository participants, or even to correct the data, I suspect you would have to go back to the source of data, which is the FIP and not the FIU.
Perfect. Okay. Vinay, are you back?
Yes, I'm back. Hi, can you hear me?
Let's give him a few more minutes to get back. All right. Let's move from.
I think Vinay's on.
Yeah, we can hear. Can you hear Vinay?
I can hear Vinay.
Perfect. Matthew, can you?
Yes, I'm back.
No, I can't, but please proceed. I don't have to.
So, Vinay, I think it'll be interesting to hear your thoughts on an AA acting as a guardian to the financial information.
Right. So, see, I think that we have to be a little careful about how much responsibility we place on the AA because, see, consent is one thing, right? And the consent artifact is great in that it provides a standardized way to record this consent and it cannot be tampered with and so on. However, the AA and the consent artifact and all of that is not a solution to the problem of what an FIU is going to do with that data once they have the data. The A cannot be the entity, the A cannot be the police when it comes to trying to make sure that an FIU does not misuse data once it has been legally transferred to that FIU. The A cannot play that role. It is not empowered to play that role, and it doesn't have the technical ability to play that role either. All the A's contribution to this is making sure that the consent artifact exists. Now, this is very important because there needs to be another enforcement authority, right? Which will either be the data protection authority or a financial sector regulator, which has, which has oversight and powers over the FIU, who will have the ability to actually investigate and redress any misuse of data that is carried out by an FIU. And when this entity, whether it's the DPA or the RBI or SEBI or whoever it is, when they are undertaking this investigation and possibly some kind of a legal proceeding as well, the consent artifact, which of which the A is like the guardian, is going to be a very key piece of evidence, a key input in in deciding whether there has been misuse or not. So I think that the A is less the guardian, is not the guardian of the data. Very simply put, I don't think that the A is the guardian of the data. The A is the guardian of consent and making sure that the consent was correctly obtained and that a record of this consent is always maintained so that if this data is ever misused in the future, the consent artifact starts out as an indisputable reference point to begin that investigation and inquiry. But that data guardian role needs to be played by another entity, probably the DPA, in association with the sectoral financial sector regulator, which applies to that particular entity.
Vinay, just kind of building on top of that, do you think there's scope for the account aggregator? And right now, I know it's only a consent in the strictest sense of the word manager, but the ability to, if I as a user want to correct my data or update my data or seek the erasure of my data, to kind of channel those requests through an account aggregator as well?
Yeah, so that I think I think that's a useful thing to think about. As far as I'm aware right now, apart from revocation of consent, I don't think that everything else is really provided for explicitly. But I definitely see merit in trying to use A's as as perhaps a channel to do that in the future. The only thing is, I mean, that is still it would be, from a technical perspective, it would end up being incredibly complex because right now the A is designed as a sort of data delivery system, right? It's a messenger. It is not meant to, for example, fetch data or update records in the databases of the FIUs and so on. It is meant to fetch data from the FIPs and transmit and deliver that to the FIU. It does not have the same ability to kind of make or help channel changes to the data that is already being held by an FIU and so on. So that would be there'd be a huge technical task to build that. I'm not sure if it's even really feasible.
Okay. I just think it's interesting because it seems, and like you had mentioned, that the consent manager concept seemed to be introduced because of the account aggregator ecosystem. But what's interesting within the law is that the lawmakers seem to go a step forward and seem to say that apart from giving and withdrawing consent, the consent manager also can act as some kind of, I'm not going to use the word guardian because the law doesn't, but seems to suggest that the consent manager can also help data subjects exercise their rights. So it just seems interesting, about how they've taken the concept of what an account aggregator does practically and kind of built upon that as well.
Yeah, absolutely. No, and I think there's definitely merit to going down that route. I don't think A is the way they have been conceptualized right now, and the way they are in the A technical specs and so on will let you do that specifically. But I mean, it is a direction this can be taken in the in the future.
But you're saying it's not technically, it's not straight. I mean, it's going to require an overhauling of the technical processes.
Yeah, I mean, I'm not a technical expert, but I would not see this as merely just adding a few additional features. This would be like a fundamental change to the architecture.
I would just, yeah, I would like absolutely agree with Vinay here, because the way AAs have been conceptualized right now, for a customer to actually want to correct information that's probably lying with an insurance repository, or a depository participant, or a particular error in their bank account statement, would be a lot of work for an AA to actually undertake and partner with all the FIPs to ensure the correction is made. That's not what the current regulations envisage, at least.
Okay.
Perfect. So, everyone, I'm very mindful of the fact that the vast majority of the audience consists of people who are potential FIUs or TSPs slash middleware creators, right? So, if we can shift focus from account aggregators themselves to the next level, which is how do we characterize an FIU? Ankita, do you have thoughts on that? Or Adya, do you want to start? Is an FIU a data fiduciary? Is it a significant data fiduciary? What are the chances, right?
I think, again, my take here is that the FIU, it's very likely they're going to have some kind of contractual relationship with the user. And the fact that they handle financial information, the fact that they handle financial information as is right now, I would think that they'd be data fiduciaries. And actually, the fact that they're regulated entities under the present regulations, most definitely, I think significant data fiduciaries, which would, I'm just thinking from a compliance perspective, be a lot of things to get in check to comply with the law, the new law at least.
Right. So, Vinay, do you agree with Adya? And if you do, how practical is it to expect, let's say, a startup in that space to comply with, for example, the DPIA requirements, right? The requirement to do an impact assessment. And all of those slightly enhanced requirements for significant data fiduciaries. Or do you disagree with Adya?
So, no, I think I don't disagree. I think there is a chance that AAs will be classified as significant data fiduciaries. But I am still hopeful that recognizing, this specific concept of a consent manager in the data protection bill will allow for AAs to be, to be treated in the right way, in the sense that, and this is the point I was making earlier when, my connection kind of gave up, which is that while, of course, it's very possible that they will be considered significant data fiduciaries. The A's don't actually fit very well into the real concept of a data fiduciary, because they're not really processing. The data is encrypted. They can't even actually access the content of this data and so on. So, given that, I'm hopeful that all of these requirements, impact assessments, all of this stuff is applied, in a way that actually makes sense to this industry and to the participants here. This is the kind of thing where we'd have to rely on a good data protection authority to exist, which will kind of do this in a sensible way, which is friendly to industry and doesn't stifle it.
Vinay, I think what about FIUs? Were you talking about AAs specifically?
Oh, I was talking about A's.
Yeah. What's your take on? FIUs?
Okay, on FIUs. Yeah, so okay, FIUs, I don't know. I don't know if they will necessarily be significant data fiduciaries or not. It will really depend on their scale, because the concept of what is significant data fiduciary has not been fully prescribed in the data protection bill. It only talks about some of the parameters. Not some. Actually, I think it exhaustively enumerates the parameters, but doesn't set numbers. It doesn't attach numbers to those parameters, like volume of data processed and turnover of the company and so on. So it only talks about the categories. It doesn't put numbers there. So I think that it will really depend on the size of the FIU. If I don't know, if PhonePe is an FIU, then yes, chances are that it will be a significant data fiduciary simply because of the size of its business and the number of users it has and so on. On the other hand, if there is an FIU which is just a tiny little startup, I don't think that should be it should not be considered a significant data fiduciary. That just wouldn't make sense.
Even with the sensitivity of the data attached?
So I don't think that, yeah, simply because, if what we're saying is that any entity that handles sensitive personal data will automatically be classified as a significant data fiduciary, that to my mind doesn't make much sense. It doesn't make logical sense. The whole concept of having a data fiduciary and then this other concept of a significant data fiduciary is to say that, hey, there are these, there are some like critical utilities and companies that just are operating on a much larger scale than others. So they need to be subject to some additional processes and checks and so on. So I think that's the way it should be looked at. And my sense is that when the DPA lays down these guidelines about what constitutes a significant data fiduciary, it will probably be an and, not an or. Like it won't be. It'll have to be that, hey, you handle certain classes of sensitive data, and the volumes cross a certain specific threshold, and your turnover is also above a certain amount. I don't think it shouldn't be or requirements where even if you satisfy one of those parameters, you automatically become a significant data fiduciary. That wouldn't be logical to me.
Okay, perfect. And again, I'm going to put the same question to all three of you. What are the, and Vinay, I think to some extent you've answered it, but presumably, what would a technical service provider require to sign with an FIU? And I'm presuming, are we all agreed that they would be signing a data transfer or a data processing agreement? And that it would be inadvisable both for the FIU as well as for the TSP to provide any services without a detailed data protocol set in place. Vinay?
No, I absolutely agree. I think it's better for the interests of both parties to do that, even though it's like a little bit more work. Simply because I think right now we're still, in India, the data economy is still like the Wild West in some ways, in the sense that, while everyone is trying to conform to, best practices and global standards, the Indian law doesn't prescribe much, and you can, sometimes people do get away with not being very careful about how they structure these arrangements. But I think with the PDP bill coming in and with AAs coming in with the kind of auditability that the consent artifact brings in and all of that, I think it's very important that you have those kinds of formal arrangements in place. They don't need to be extremely long agreements. They can I actually think that there's a lot of scope for standardization in these kinds of things. And I can actually take a cue from the consent artifact itself, because I think that provides a baseline for the kinds of things we need to provide for in these agreements. But they are very important, I agree.
So Vinay, it might surprise you to know that since 2018, the TDSAT has actually been giving fines for violation of the Reasonable Security Procedures Code. And those fines have not, originally the fines were a couple of lakhs, 5 lakhs, 10 lakhs. Over the last 12 months, they've gone up to 50, 60, 70 lakhs. So the myth that we don't, that there is no fining mechanism or penalty for violation of data, that's slowly changing. Plus, if you look at the consumer protection law, it says very clearly that a consumer can sue an FIU, for example, for any data breach, violation of contractual provision, etc. So while we're waiting for the new bill to come in force, please don't be under the presumption that the old law means you can do whatever you want with data, right? That was 2010, and that has changed clearly.
Absolutely. I wasn't aware of the TDSAT issue,
Yep.
actually. Thanks for
So
bringing that up.
Vodafone just got a 60 lakh fine a few months ago. Anyway, yeah. So moving on, Aryaman, do you think we should get the audience involved now? Because I'm aware that it's an hour and 10 minutes and nobody's popped on. And as usual, Nikhil has 4 questions already in the list. So maybe inviting him on first might make sense.
Sure, we have a few folks who've asked questions across the chat and the questions tab, so we can really address those. Just a reminder, please put your questions on the questions tab. Uh, we had we have a few. Nikhil, if you're here and you'd like to come and speak, please do raise your hand. Alternatively, if anybody else would like to speak, please click the raise hand button and I can bring you on stage to ask your question. So we have Nikhil.
Yeah. Hello. Hi everyone. So
Hi, Nicole.
yeah, I always have questions, and like I have been following, the bill and the comments that the recent panel put out, and yeah, I had some questions around not just the personal data, but non-personal data as well. So, for instance, what exactly is a data business? Uh, like, do you think somebody like Google would uh, be classified as a data business, and if so, it says that data businesses would need to publish their metadata and non-personal data. So do you see somebody like Google or Amazon complying with this?
I'm happy to
Vinay,
take
please.
the lead on that. So I think we shouldn't get ahead of ourselves with this whole non-personal data committee report. I think it's very early days. It's only a draft report which the committee has come out with, and at best, all that they can issue at the end of this, even when they finalize the report, is just recommendations. It's completely up uh, to the government to do whatever they want with those recommendations. They can choose to just ignore it completely. They can, on the other hand, they can choose to actually take up the suggestion. So to begin with, we're very far away from any of these these concepts actually becoming anything close to law. Okay, so that's one thing. The committee does not have the power to actually, I don't think their terms allow them to come out with a draft law or anything like that. They're just supposed to submit a report. Number two, I honestly, if you ask for my unfiltered opinion on this, it makes no sense.
Vinay, if I can interrupt you, you're recorded and on YouTube, but go on.
Sure. Thank you for that warning. But I honestly don't think that the concepts which are contained in the draft report, which we've seen right now, I honestly don't think that they are possible to even implement in the first place. And two, I don't think that they're a good idea at all. Of course, it's my personal opinion. I'm not speaking on behalf of anyone or any organization here. But I'm happy to put my name to that opinion. I've said it on Twitter as well. So it just doesn't make too much sense. So I think we shouldn't. It's too early to devote too much attention to those concepts right now, even though they are like potentially earth shaking. I don't see how they can really happen. I think that in many ways it would end up being like a nationalization of many people's businesses if some of those concepts actually become law. It really doesn't make sense.
Right. I think
Yeah.
Nikhil, I think the baseline response on this and on many data debates is something that Justice Sri Krishna came out about 2-3 days ago, where he said that over the last few months/years, he's seen the Indian data debates move from being about protecting personal data. Hello? Hello? Can you hear me?
I
Can
can
you
hear
hear me?
you.
Yeah. Has moved from the basic idea of protecting personal data and privacy to a slightly more jingoistic nationalist agenda, which may have lost all conceptual. And now this is where Sri Krishna very politely stopped saying it, and I'm adding my 2 bits in. So it's lost all congruity and connection with traditional data law and privacy principles, right? So globally, there is a way in which data law has evolved with the non-personal data debates and the way that has been framed, but but also with regard to the government's ability to source data under the latest draft of the Personal Data Protection Act. You can see that there is a move away to government right over data, or community, what they call community right, which is paraphrased government rights. That is worrisome for someone who thought this was a rights oriented process whereby I as an individual have rights over my data. That said, so we don't know, we're in uncharted territory, because globally both of these, non-personal data as well as government access, are both things which have been problematic, and the laws globally have kind of ignored or at least controlled this instinct to a large extent. And we'll also have to see, there is a recent judgment of the European Union Court of Justice, I think last week sometime, which says that data transfers from Europe, I mean, they talk specifically about the US, but they say data transfers from Europe to other countries which should materially depend on our assessment, not just of the contract, but also whether the legal system of the other country recognizes private rights over data. So immediately you can see, both from a politics perspective as well as from a economics perspective, as well as very clearly from a survivability of the ITES industry perspective, everyone's turning around and saying the US government's ability to interfere in data transfers from Europe into US means that we are not going to easily allow US data transfer. Now I'm just saying, if you apply the same standard to the Indian bill, apply the same standard to the Chinese law, or apply the same standard to the Singapore PDPA, and you will see that transfers from Europe, from a data protection perspective, may be problematic. And unlike, say, China or Singapore or the US, none of them have an outsourcing industry like we do, which depends on transfer of data from Europe. So I have a feeling that in light of this judgment called Schrems 2, we will have to look at changing some of the government access, NPD, community rights perspective, with which some of these laws are being changed, unless we want to kill the ITS industry. And as you can see, there's still a little bit of politics to be played before the PDP bill becomes law. Vinay, any take on this as someone who's also interested in politics?
Yeah, honestly, I think, sorry, I think there's a bit of go. Is everyone able to hear me?
Yep.
Okay. So I was saying that, it's, I mean, we're kind of in unprecedented times, I think. It's a lot of the things that are happening around the world with respect to, data protection, data sovereignty, regulations around internet businesses, a lot of things that are happening. No one could have really predicted, a couple of years ago, and it's driven mostly by geopolitics, and issues between the US and China, India and China, and a bunch of other interconnected issues. So I definitely think that so far we have pushed a fair bit. By we I mean India has pushed a fair bit against. Gone kind of against the grain on a number of issues, on issues like data localization and so on. And so far, we have managed to not accommodate most of the pushback from from other countries, from the West, and so on. But there is, I think, some point where we might go too far. I think that, for example, some of the concepts which are in the in the NPD committee report, those would be a step too far, because it would result in uh, you'd actually be expropriating the property of companies if you were to implement some of those suggestions, and that would come with massive backlash from the countries that these companies are from, primarily the US. So I think that would uh, that would spark a huge backlash, which in my personal view doesn't make too much sense.
Okay,
Right.
Nikhil,
Yeah.
why don't we go to your question on the sandbox? I think that would be very interesting for everyone.
Right. Regarding this draft, my first reaction as a tech guy was, authoritarian outrage, and I just wanted to take it up with you guys if the legal opinion is along the same lines. So yeah, let's take it up on the sandbox. And before that, I had one question regarding the way when I mentioned that we need a detailed data protocol and data transfer agreements between TSPs and FIUs. Would Do you think is this going to be a part of the model agreements which you guys are working on with Sahamati?
No, I think Sahamati's model agreements are FIU, AA, and FIP. TSPs are entirely commercially driven, and you guys need to manage that process yourself.
Okay, cool.
Not on the table right now, at least, unless Mahesh wants to jump in and clarify the future of it, how he's thinking of in terms of the future.
No,
Aryaman, Mahesh? Okay, Nikhil, I think we can move on.
So Mahesh isn't here, but yeah, I think maybe we can work through some of the audience questions. There's quite a few that I see that have come up.
Sure.
Maybe that would be a good step.
Go on, Aryaman. Pick one.
So, okay, let's see. We've got one. We're going to go on the questions. So please put the questions in the questions. It's a little hard to keep track of the questions in the chat. So there's one which asks, wondering if you can shed light on how the Ocean interfaces with AA frameworks. That's the Open Credit Enablement Network, which was launched a few days ago. Yesterday was, I believe, the first sort of public demo of it. So, do any of you want to take that? I mean, I could also possibly shed some light. Would be interested to hear your views on this.
Aryaman, why don't you go first and then we'll join in?
Sure. So, Mandar has asked this, and the way that this I'm just going to call it Ocean works, is that you'll have these loan service providers who help facilitate access to credit through a standardized API for data. So what these LSPs will do is that they will sort of ask businesses or individuals, they'll say that, look, we'll connect you with a network of lenders, give us consent to share your data. So some of the data that will be shared will be data that's held in FIPs. So data such as bank statements, GST statements, and things which may lie with traditional FIPs. Some data will lie with that LSP itself. So if you have an LSP which stands for loan service provider, like Zomato, then if a Zomato restaurant wanted credit, in addition to sharing their GST filings and bank statements, they would also presumably share their Zomato data. So what are their average order value, average rating, all of that kind of stuff. So consent could also be given for that. So account aggregators will still be in the workflow from the perspective of giving consent, and they will facilitate the access to that data for the lenders. So the Ocean and the LSPs rather, I think Ocean is an umbrella term that refers to a variety of different entities. So you have lenders, you have LSPs, and you have the borrowers, who could be individuals or businesses. So the LSP, which is the loan service provider, that will be like an interface, which is, let's say, set up inside Zomato or Ola, or Uber, or Swiggy, or any marketplace. And the reason for that interface existing is that it provides a standardized sort of pipeline for streamlining the flow of data to n number of lenders. Today, if I wish to kind of plug lending and credit into something like Ola, Ola would have to come and say, hey, look, my API works like this. Bajaj Finance would come and say, okay, my API is like this. They'd figure out some custom integration, which might take them months, and then they can begin actually rolling out products. But then if a new lender came on board and Ola wanted to support multiple lenders, that process would almost start from the beginning again. Even if Ola said, guys, we are not customizing for anybody, we are just offering a self-serve API for everyone, that would still not help these lenders if they were to go to Uber. So just to make things more efficient, if having one standard interface will enable every lender to support most credit marketplaces and allow most credit marketplaces to plug into many lenders easily. And the way the data would flow would still be via consent through an account aggregator workflow. So I hope that sheds some light on how it works.
Right. So yes. So in response to the question, I think the LSP infrastructure is primarily independent of the AA infrastructure that's been put in place. But when Ankita logs in, because Ankita did the whole LSP Sahai contractual framework, when she logs in, I'm hoping she can give us a little bit more of a feedback on at least how the GEM Sahai app and the licensing around that works. But shall we take another one for the time being? Raghu has a couple of questions. Do you want to ask those, Aryaman?
Yes, sure. We can do that. So I'm just putting some of these comments in the answered section. Mandar, I hope that was useful. And when Ankita's back, we'll have her also explain the Sahai framework as you were saying. Raghu's questions over here. Will data protection graduate into fundamental rights under Chapter 3 of the Constitution down the road? Your thoughts, please. Excellent question.
Right. Fabulous question. All I have to say is two years too late. I think it graduated into fundamental rights in 2018. The exact depth of the fundamental rights we'll know later. But in a judgment popularly known as Puttaswamy, the Supreme Court very clearly said that rights of privacy are parts of an individual citizen's rights. I hope that answers the question. I think there's a fabulous question.
Clarify.
Go on.
Sorry, so you're saying that according to this precedent in this Supreme Court ruling, the rights that are defined in the Personal Data Protection Bill, which are the right to be forgotten, the right to data confirmation, data updating, data portability, these will be fundamental rights. You're saying it's implied because of that previous judgment, or is it explicit in the PDPB?
So it's explicit in the previous judgment that rights of privacy are constitutional rights. Some of the judges disagreed on what rights of privacy means, right? But by and large, for example, I think it's fairly clear that some variation of a right to delete will be a constitutional right, right? In fact, we're in court in Karnataka on two separate occasions arguing that a constitutional right to delete exists, and that the constitutional right to delete means that certain actions, I can't go into details, but the certain actions need to be taken because of right to delete, not just by the government but also by large search engines, etc. If I go on further, I'll be giving too much data, too much information on the particulars. But by and large, the argument is that all of these have attained constitutional status of different degrees, right? I think Raghu's got a point which talks about whether privacy versus protection is a right in rem or a right in personam. Raghu, just to quickly answer your question, it is a right in personam by virtue of contract, but by virtue of Puttaswamy, it is also protection is a right in rem. You can claim that right. The exact contours of the right to protection, the in rem, will come up in the next few cases. But you can see that Delhi High Court, Karnataka High Court, Kerala High Court, I think the Calcutta High Court have all said that a right to privacy and protection in REM is granted under the Constitution. And I'd love to have a debate about. Sorry.
I was just saying that I'm enjoying this. I think we're covering some great questions, and I'm enjoying the audience interaction. Ankita, are you able to hear me now?
Yes, sorry, I dropped off.
No worries. So, Ankita, there was a question earlier which was asking whether how the Ocean framework plays into account aggregators, and
Yes.
I'd love to get your view on the sort of contractual aspects of LSPs versus account aggregators.
Absolutely. So, very interesting question. I think both serve very different purposes and needs. While the entire LSP framework and the open credit enablement network is to kind of provide easy access to lenders with respect to credit facilities that can be accessed, it serves one specific purpose. The AA framework, on the other hand, is supplementary to to this entire setup, which is the access to financial information for being able to lend. Right. So, of course, there is an interaction between the two frameworks and how it would work. But I think both serve very different purposes and will have to work with each other to be able to provide complementary services.
Is Ankit in the audience? If he is, maybe we can call him on. Aryaman? Ankit from IC.
Oh no, Ankit is not here. Ankit is not here. Ankit is not here, but we do have another question which I'd like to say, and that question is from Mahesh Govind. So some AAs are showing customer data from their AA app. In this case, the data user is the AA's customer, who is not an FIU. Does it create unfair advantage in favor of AAs? Does the law say that AAs can enable customers to see his, her, I'm assuming he meant data? And I think we've sort of covered this in previous sessions, but it's clearly a very pressing question for many people. So maybe we can address it again.
Right. So very simply and quickly, AAs are allowed to show customer data to the customer. That's part of the function that the AA does. The law specifically allows that, but the AA is allowed to only be in the business of account aggregation. So you can't actually make, you can allay costs, but you can't be in the business of processing, providing services on the basis of that data. So I don't think the AA is in any way competing with an FIU. The AA is just a pipe. The pipe can end up with the FIU, and that will have economic consequences. But the pipe can also end up with an AA app, and that will not usually have any economic consequences. Does that help? I hope that helps. Vinay, any thoughts on that? The AA's ability to kind of show data to a customer by themselves. Does that compete with an FIU?
Right. No, I don't think, as you said, A's are explicitly barred from doing any other business. So you can't make money off of, the AA entity cannot make money off of anything else, right? And cannot enable transactions. Like that's another explicit restriction in the master directions. But simply displaying the information, I don't think that is that's barred as such, and I don't see that as actually competing with an FIU. I understand that it can look a little bit like a PFM kind of use case if you do that, but the point is the PFM would have to make money in some other way, and the A would not be allowed to do that.
Sorry, go ahead.
Right. Ask your question? Should I take that question?
So I just want to stay on this for a second because I think, in a similar vein, another question which keeps coming up is that AAs actually have some useful metadata about the customer. Even if the AA doesn't have the data about, let's say, what is in the customer's bank account at this time, they do know that, okay, Aryaman is giving consent to share 6 months data for this purpose code with capital float or with, just money or something like that. So the AA does have that metadata. One question which keeps coming up is this metadata might be useful for, trying to push products to the user or monetize in some other way. Could you address those questions and concerns over the usage of the metadata to push transactions to the user?
No, but
Okay,
Aryaman,
so
they
see,
cannot. Yeah, when I go on.
sorry. So I think that they can't do that. I don't think AAs should do that because AAs are not allowed to do that. They are barred from doing that. Uh, the the way I'd see, like just taking a step back from the specifics, the way I'd see it, I think for people building an AA business, you have to look at the AA as a utility type business, right? You can try to also build adjuncts which kind of leverage the AA capability outside of that company. You can have a sister concern which has an arm's length relationship and uses the AA services of your AA entity and does something over and above that as an FIU. But that would have to be a separate entity. That, I mean, it sounds like it sounds kind of like a waste of people's time to say, hey, set up two companies, make them sign a contract, and then effectively do the same thing that you wanted to do in the first place inside of the AA entity. But there are good reasons, both legal and technical and from a regulatory perspective, to say that the AA entity, even if it may have a common parent with another entity which is an FIU, which is then going to do certain things with with data that is fetched from FIPs and all of that. It needs to be done in the right way. Those businesses need to be structured in the right way. And the AA entity, the company that holds the AA license, cannot do those other things.
Makes sense. I believe you're about to take Vivek's question, right, from Capital Flow?
I think Matthew had a point on this as well.
Sorry, Matthew.
No, I think we've spent enough time on this. I agree with you guys. Absolutely. I don't see any room for a competition between an AA and an FIU. I think the roles are defined. In fact, if the AA tries to get adventurous, I think we'll see the RBI whipping them into shape.
Yeah, agreed.
So Vivek, Capital Float, sorry, Vinay, you had a...
Yeah, no, I think the answer is yes to Vivek's question. The A can charge the user directly. In fact, I mean, I believe that that's actually the ideal business model for A's, because that kind of aligns incentives perfectly and makes sure that the AA does not have any conflicting or perverse incentives when it comes to looking out for the for the good of the end user. The only problem with this is we know that we all know that from a practical perspective, this may not always work. There can be certain large segments of users for whom it may not be possible. It might not be possible for them to pay A's, and there might be good, practical reasons to say that A's should be able to also be paid by FIUs and so on. But definitely, there is absolutely no problem with an A charging users directly. That's actually the ideal business model.
I think the way you need to look at this is that the user is the owner of the data. And I think it's a fundamental problem across A's, FIUs, FIPs, even us lawyers, regulators. This is not an FIP's data or an FIU's data or the A's data. This is fundamentally the user's data. Now you're providing the user a service by piping that from point 1 to point B. And because you're piping that from point 1 to point B, you can charge them some money. Still doesn't become your data. It's still the individual's data. And as long as that is clear, I think the rest of the system makes sense. Right? And so obviously you can't stop an AA from piping that to the person who owns it. Right? And that's the logic. And of course, piping it costs a little bit of money, and therefore you charge for that process. But that is not the role of an FIU. An FIU's role is in processing, analyzing, drawing conclusions out of this data, and that is something that an AA cannot compete with. right? But they can pay for they can charge for just the piping. I think we should take another question from Ankur from FlinkPay, where Ankur says, do current accounts also fall under the AA framework? Yes, it does. Aryaman, are we agreed on that?
Yes, agreed. So if you go on api.rebit. Which is rebit.org.in, you'll see the 23 different types of data that have currently been earmarked for inclusion into the AA framework. There'll probably be more data types added to that, but in the current specification there are provisions for current accounts, savings accounts, other kinds of um, savings instruments, as well as a lot of other types of financial assets, including equities, mutual funds, REITs, InvITs, bonds, government securities, etc. And as I said, we expect to see more also come in. One interesting thing, Ankur, is that the sort of user flows for current accounts, that is for businesses, is something which might need to be worked on separately. So there might be an account aggregator that specializes in serving, let's say, individual users, and those users could be, let's say, anglophone, tier one urban smartphone users. There could be another AA that actually goes after feature phone users from rural areas. And there could be another AA that goes after SMEs, because those SMEs will have different authentication workflows. Because who is the person responsible, or authorized rather, to share that SME's data? So these are open questions that I think the industry needs to work towards, and I'm sure that will happen. Matthew, Ankita, Adya, Vinay, do you guys have any thoughts about this? Like, how does the SME authorization chain work? Who's responsible or authorized to give consent to say, yes, share my company's data with this person or that person?
Yeah, so I think this is a problem, and we need to solve it quickly. There's been we need some kind of we need to solve KYC and consent for businesses. That's not been solved so far. Right now, I don't think there's any solution. There's no broadly acceptable solution that exists right now for how to how to take consent from any entity apart from a natural person. And we need to solve that. So we need like an Aadhaar for business or something like that to solve the KYC problem for businesses, and along with that also solve the consent problem. It's they're not exactly the same thing, but as you know, they're quite interrelated.
Yes. So there are some discussions about to create a unique enterprise ID for that in PAN. So I think as you rightly said, the solution needs to come, and maybe it will come as a combination of private and public, public infrastructure, private innovation. Saying something?
So I think one way to one possible path to the solution is using the e-sign infrastructure to basically say that perhaps maybe have a centralized way of recording that, okay, for this company, this is the person who is allowed to give consent on behalf of this company, and so that needs to first be recorded somewhere, and that needs to be recorded in a verifiable way, a way that is verifiable by third parties to be able to say that, hey, actually this Vinay is allowed to is allowed to sign on behalf of, or to give consent on behalf of XYZ company, private limited. Right? So you need that first, and number two, you need to be able to use something like e-sign infrastructure to actually be able to give consent or signify your consent to certain things.
You know what, Vinay,
Right.
if I can
Just to
go on.
no, go ahead, Matthew. I was making a different point.
Yeah, so I was just thinking that problem is actually solved, because if you've got a board resolution or some kind of authorization which you can show as proof that you're authorized to act on behalf of a company, and you can then verify yourself using Aadhaar, Yevo, all of that, then the question of KYC for an SME or even authority to act in proving all of that digitally ought to be very well sorted. Of course, there's no central repository, but generally, as someone who believes in autonomy and freedom, I find the idea of the requirement for a central repository absolutely opposed to the idea of independence and ability to prove this contractually. Because even if I'm actually physically signing an agreement in front of you, Vinay, there is only one way you can check whether I am authorized to represent my company, which is to ask for a board res. And as long as you can get that, then you should be able to act on that, right?
Yeah, absolutely. So I agree. Right now, it's only the board resolution. The only problem is, as you said, there's no. See, it doesn't have to be a central repository. It can also be some kind of a federated solution. Like if you look at eSign, eSign technically speaking is actually not like leave aside Aadhaar eSign, but the general digital signatures are not you know they are not centralized in the way that say something like Aadhaar is. But at the same time, it is still possible to trust it and to actually verify that a signature is valid and so on. So some similar fully electronic, non-repudiable way of saying that this person can act on behalf of this company, that would just make electronic transactions for SMEs much easier. That's all. The path exists even today, but that means that the company that is, or the entity, the intermediary that's kind of in this transaction will have to look at a board resolution. They'll have to have some way of trusting that this resolution has not been faked. There's no way to verify it. So it creates a lot of problems of trust and creates a lot of friction, which is taken away to an extent when it comes to things like eKYC, which provides a standardized way to carry out KYC and along with that to also trust that a person who is given consent is who they say they are and is authorized to act. So basically, we've solved eKYC for individuals. We've not solved it for companies.
So I'd like to just interject here. We have a little bit of a time constraint because we have a session beginning at 5 p.m. So I'd really like to invite Mandar onto stage because I think he made an interesting point about account aggregator business models. So Mandar, here he is. Just bringing him on now.
Hi, am I audible?
Yes. Hi, welcome.
Yeah, hi. I would just sort of making the point that in the context of the scope of activities that the account aggregator might undertake, right now it's a data blind sort of conduit from FIP to the FIU, right? But from a business viability perspective, and this is a point that I've made earlier when when we met at DMI's office. Is that perhaps the Sahamati can policy advocate the RBI on making it wider to include some sort of analytical activity as well, some sort of analytics built upon the data that they anyway sort of pass through. For the simple reason that the existing business models that we've been talking about may not be viable for a vast bunch of users, especially to use the existing sort of division that we use, Bharat and India. I am not too sure if a bunch of users in rural India are going to be comfortable paying, and that goes then again with the adoption of the tech and the infra that we're building, right? So there is a tension here. The tension is solved somewhat if we let the account aggregator also sort of offer some sort of analytical the analytical layer to add the analytical layer to the service, right, which is currently absent. So yeah, I mean that's really the point. And of course, I mean I take the risks to it, and then perhaps we can also think about as a community, think about the mitigants to it and include that in the AA regulatory framework. Thanks.
So Mandar, the logic that at least the logic that I would like to think is that there is no incremental cost to piping data from an FIP and there is no significant incremental cost from piping data from an FIP to a data subject, for the lack of a better word. And therefore, even though AAs are permitted to do that, assuming a market of freely operating independent AAs, assuming that cost is so low, then wouldn't we just leave the free market for each succeeding AA to undercut the other so that there is faster adoption? Because after all, that would permeate, that would involve greater accumulation of customers and lesser cost and therefore greater profitability. So rather than mandating and permitting an AA to do some other business, which could create a conflict between the piping role and the business role and whether the two are tied in, and how data considerations and privacy considerations and economic considerations interact in that one mesh, wouldn't it just make sense to have, say, this is the pipe, you're the utility service provider, you're allowed to charge for this one fairly useless, innocuous thing, but if you charge too much, people will stop using it and will go to someone who charges much lesser. To me, that's a far more long-term solution than trying to kind of allow them to do other things. But Ankita, Adya, when I step in, if you disagree, but I think the RBI has got this part of the structure correct, which is a pipe should only be a pipe.
Yeah, Matthew. I mean, I would agree to what you've just said, because if an AA starts undertaking analyzing the financial information, then it's practically playing the role of an FIU, which would defeat the entire purpose of an AA being data blind and acting only as a consent broker, or being a part of the entire consent architecture.
Yeah, I agree completely. And the question after that would be, okay, they analyze the data, but then presumably they're supposed to make money off it, right? Which means who's going to pay them money for that analysis? And that's where I think it starts, incentives start getting misaligned, and it probably doesn't, it can lead to a lot of bad outcomes.
Just bringing Mandar back, I believe he raised his hand.
I get that, but the question is whether we want the data blindness as an objective. Are we getting, like, the limited point is that if we get too dogmatic about that division of labor, we stand to risk business viability and adoption. So, I mean, unless we figure out a way of sort of charging, on the B2C loop, and frankly, my experience, and I'm sure that y'all also are part of the ecosystem, so you're familiar with it. It's not easy in the US you can have business models around it, but in India you can't have business models where the consumer pays the utility viably over a long time. So sustainability is a big problem. Perhaps we might want to revisit this issue in the light of experience, because right now, we're in the nascent stages of evolution. But something that we might want to revisit at a later point in time, because the dogma surrounding the division has to confront the lived realities of business in India, right?
Mandar, but I mean, just to give you a counterpoint, the dogma surrounding the division is a function of economic history of monopolies, state-granted monopolies ever, right? So your data pipe is a monopoly granted by the state. The moment you're able to tag on additional businesses with that monopoly, globally the consensus is that leads to inefficiencies. So either you try and take away that monopoly itself and say anybody can be the pipe as long as you fulfill 1, 2, 3, 4 conditions. But as long as you say you can only be the pipe as long as you satisfy NBFCs, you are only located from so many countries, you are this, you are that, as long as that exists, then the flip side must be that you should not be allowed to profiteer with allied tied-in businesses. Similarly, if you were to allow tied-in businesses like FIUs, then I would think that competition law concerns also would arise. So I think, yes, it would be good to relook at this 5 years after operation of the EA ecosystem. but I don't think we should jump to this conclusion because of a immediate feeling that businesses might be affected. Let's also remember that as long as the pipe itself as a separate entity does not do any other business, other associated entities can tie up with the pipe to do business. So it's not as black and white as you seem to think, Mandar. At least I think the four lawyers on this panel suspect that we can find solutions that would keep the RBI happy as well as keep you happy. Vinay, what do you think? So anyway, that was on a lighter note, but anyway.
And Mandar, just to add in here to probably give you a parallel example, at least with respect to AAs, the idea is to ensure transparency in the entire system, right? Which is why the RBI also requires you to kind of have your pricing policy on the A platform, right? So it's aware the pricing policies between different FIUs. You wouldn't want an AA to prefer or give preferential treatment to a specific FIU just by being paid more. Right, so there are multiple factors that kind of come in by giving AAs an additional role than what they're essentially meant to do.
Yeah, I agree. And I think that the business model problem should ideally be solved with FIUs paying for data fetches. That's still not perhaps it's not the platonic ideal, but I think that's the acceptable amount of compromise that should be allowed on this. I think allowing AAs to use that data to make money, that is probably not the right way to go.
So I'd like to just take one last question, and maybe I'll offer my own view, and would love to get the panel's view on it before we can kind of do the concluding remarks. So the question is from Vivek at Capital Flow, who says, why do we even need an AA in the middle? Why can't the FIU directly talk to the FIP over a well-defined protocol for consent and data flow? I think it's a good question, and I think in the design of the AA framework, other models were considered, including the model which you're describing, which is how things work in the UK, for example. The issue with that is that you have hundreds of FIUs who wish to collect data, and if those FIUs are responsible for collecting consent as well, you have one issue wherein the FIU is not incentivized to educate the user properly about the ramifications of giving that consent, because the FIU's incentive is just to get the data at all costs. So that's one drawback there. Secondly, implementing the sort of this system across hundreds of different FIUs and monitoring whether or not they are doing it securely, they are doing it properly, is much harder than managing a smaller group of regulated players who have to prove competence and who are easier to kind of keep a hold of. So that is the reason why it's gone in this direction. Also, if you look at the way that open banking was implemented in the UK, many of the FIUs are not able to implement the APIs properly, or the FIP. So there's an implementation headache, and kind of getting these specialized players in to do the job is potentially more feasible than asking hundreds of people to do it. So that's my take. What about Jenny? Do you have a view on it?
Yeah,
no,
so I think
completely agree.
Go on, Vinay.
Sorry. No, I completely agree. I think the whole point of this is to make sure that again, it's just about alignment of incentives, right? And what the role of a specific actor is. It is not the responsibility of an FIU to look out for the data protection interests of the end customer, right? That's not their business. In fact, the incentive for them is to do the opposite, which is collect as much data as possible. And I think it definitely makes sense to have an intermediary whose only job is to look out for the customer, and who is legally required to to operate in a way that kind of works out to the benefit of the end user. And the hope is that, everything can't be written down in regulation, but the hope is that the AA ecosystem will foster competition not only around just like who can get the most installs and all of that, but who actually manages to look out for a user's privacy rights the best. That should actually be the vector on which AAs should be competing. I hope that that's what ends up happening. But of course, that whether the ecosystem evolves in that direction or not depends on how we all as a community act, and also how the regulator acts, like how seriously the RBI kind of looks at this, when it comes to, say, designing these consent screens and all of that, how close a watch is the RBI going to keep on A's to make sure that they comply with the law, not just in letter, but also in spirit. I think if this is done the right way, it provides a much better experience for end users and protects their rights much better, which would not be possible in a situation where there's only an FIU and an FIP. Even though that might solve the technical question, having standardized protocols, it will solve the technical problem of how to exchange this data easily, but it doesn't solve the public policy and legal problem of looking out for that.
So before we move to our next session, would you like to make any closing remarks, Matthew, Vinay, Ankita, Adya?
Yeah, so I just like to point out that this is a fast evolving space, including its interaction with, for example, OCEM, but also its interaction with the new data bill and the interaction between the RBI and the new data SAR that's going to be kind of appointed under the bill. So watch the space. Just remember, from the perspective of middleware providers and from the perspective of FIUs, that you don't make the mistake of assuming that this is a self-contained ecosystem. This is an ecosystem that continuously talks to the reasonable security procedures guidelines under the IT Act right now, but also continuously will talk to the new law when it becomes law. And therefore, think about how is it that I can remember that there is a requirement to comply with all of these laws, and therefore put that into the mix. What I find usually when I interact with a lot of players in the AA ecosystem is that there is an assumption that because we've come this far under the RBI aegis, the rest of the laws are irrelevant. 2 decades of doing this, and I think Vinay will agree that soon the rest of the laws will slap you in the face if you take that approach. Remember that the AA ecosystem works jointly with the rest of the laws, and build your business in a way that is consistent with the AA ecosystem, as well as India's data protection law, as well as the General IT Act, etc. That's my only take. But Adya, Ankita, Vinay?
No, okay. I would have a quick input for, I think, all the middleware and technology service providers that have mostly been a part of this session as well as the previous sessions. I think their data obligations stem from multiple facets, right? Of course, there is the data regulations that are applicable to them directly. There are also contractual frameworks that will have to be put in place when they either act as a technology service provider to the AA or to the FIU. So their ability to ensure compliance with the law needs to be very carefully thought out from the different facets that they are constantly interacting with. And there isn't a straitjacket rule to that just because they are partnering with an FIU, they need to comply with the same data protocols as a regulated entity. So their access, their processing of data and storing data needs to be very carefully thought out.
That's a great point. So with that, I'd like to thank all of you. Thank you, Vinay, Matthew, Adya, and Ankita for that amazing session. I really enjoyed this one. It's so vibrant. There's so much interaction from the audience. I think it's great. Matthew, thank you for putting your email addresses on the chat. So everybody, if you click on the chat button, you can find Matthew, Adya, and Ankita's email addresses. And
I didn't want to give Vinay. So Vinay, if you want to share your email ID for contact, please do. Or if you tell me, I can put it in. But perhaps you want to keep that. I don't know if you want to keep that private or not.
No, it's totally fine. It can be shared. Okay. Plus, easier way to actually contact me is perhaps Twitter.
Super. So once again, thank you all very much, and thank you, audience. We'll be back in 5 minutes with our next session of the day, which is we'll be in conversation with Mr. Arvind Kapil, who is the retail lending head of HDFC Bank. So stay tuned for that. It promises to be very exciting. Once again, can you please have a warm round of virtual applause for all of our speakers. Thank you so much, Matthew, Vinay, Ankita, and Adya. And everybody else, we'll see you in 5 minutes.
It was a lovely session. Thank you.
Thank you,
Thank you
Arun.
so much.
Yeah. Thanks, Arvind.
And then